I have the honor of introducing our next panelists who are going to discuss the importance of early appointment in cases involving defendants who might have an intellectual disability or might have a mental health diagnosis or may even just be a mental health distress. The panelists for this session I have met and I have known, but I can already tell it's going to be a treat today. And so thank you both for being here. This session, we're going to learn about the right to counsel laws and why the benefits of early assignment for defendants who have special needs, whether that is mental health, intellectual disability, comorbidities of substance use disorder, or maybe even tertiary diagnosis of all three. It's really important that our speakers will discuss how representing people with unique needs is different than representing someone without those unique needs and challenges. Kathleen Casey-Gamez is a policy analyst from the Texas Indigent Defense Commission. She previously worked as a staff attorney in the Indiana Public Defender Commission, and before that was a practicing public defender in Marion County, which is in Indianapolis. Jim Bethke, my friend, who spent a tour in Lubbock, is the director of the newly created Managed Assigned Counsel Office in Bexar County. He is responsible for all the operations, including budget, hiring, approval of attorneys to be on appointment lists, training, voucher review, and processing, and dare I say, public relations. The purpose of the office is to provide needed support to appointed attorneys, apply evidence-based strategies, and client-centered, accountable services for the taxpayers of Bexar County. Bexar County is where my husband's family is from. Welcome, Kathleen and Jim Bethke. Thank you so much for being here.
All right. Thank you. All right, so I'll be up here moving the slides and generally holding down the podium while Jim is going to work the crowd from down there. So how are the snacks? Did they turn out? Are we happy with them? Yes, no? Okay, excellent. Well, today, as just was stated, we're going to be talking about the importance of representation of people with mental illness and IDD. And we're going to go a little broader than that to actually talk about different kinds of managed systems involving public defender offices and managed assigned counsel systems. So with that, I'll hand it over to Jim.
Thank you, Kathleen. Thank you, sir. Good morning, everyone. What I'd like to do to begin, let me see a show of hands. Anybody from Philadelphia? Anybody who's watching the 800? If so, I'm sorry. How about Houston? Woo! And the first no-hitter since 1956, since we're going to be dealing with stats and stuff. So, tied up last year when I was living in Houston, literally right next door, we did lose to Atlanta, which was, that's all right. I like Atlanta too. Nothing wrong with Atlanta, but it'd be really nice to bring a World Series back to Texas. So with that, we'll go ahead and get started. And what I'd like to do before I really begin is to put on this type of program with the professionalism. It takes a lot of effort. And the team that Christy has put together, Liz, Michael, Willett, everybody, absolutely amazing for the speakers, and then with all of the technology. And then I said, I really want to have a lavalier mic, so the folks from the hotel took care of that, because I have a hard time standing at the podium. So Bexar County. Beth said I did a tour in Lubbock, actually did a couple. Did my law school there, loved it, started my practice in Lubbock, Texas, loved the community. And Lubbock is one of the jurisdictions that's done a lot for the improvement of indigent defense. We'll talk a little bit more later on the special needs office and all of that. After I spent 15 years with the state, with the Texas Indigent Defense Commission, initially the task force on indigent defense, Went to back to Lubbock for a couple years to help modernize its private defender program, then a couple years in Houston, and now I'm in my sweet spot in Bexar County. I was called and asked if I'd be willing to come to Bexar County to help set up a private defender program or manage assigned counsel. I was honored when I was asked, and then doubly honored when selected to do it. The catalyst for this office in Bexar County, I really believe, originated in 2019 when a number of elected officials from Bexar County, Judge Ronhell, Judge Rahman, Judge Stohansky, their data analysts, and a multitude of their team members came to Lubbock and spent a couple days with us to look at how we're providing these services. With that, it's like private defender, managed assigned. How many people actually know what a private defender or managed assigned counsel program does? Okay, most don't. Those of y'all that do, good. Really what a managed assigned counsel program does is three things. The program assigns counsel, which most jurisdictions in Texas, the judge makes that assignment. So Bexar County, the judiciary is entrusting us with making those assignments. With those assignments comes reviewing and processing the vouchers. So that responsibility also comes to the managed assigned counsel program. The other part, and really the part that I like most, is providing support to the lawyers that are providing these services. In Bexar County right now, we have about 275 that are doing court-appointed work. Soon that's going to transition over to our office. We have about 25,000 cases that'll get processed. Bexar County's in a fortunate situation. They have a strong public defender. They handle about 15% of those cases. Texas Indigent Defense Commission also provided them with a mental health division probably 5-6 years ago. So Bexar County's a little ahead of the curve, and then bringing this in was quite an incredible opportunity for me, because some folks said, why do you want to go back and do like manage assign? Because this concept has not been proved in a major urban jurisdiction. Bexar County now has a unified defense delivery system. One of the things that Dr. Keller talked about was the importance of systems, whether it's the system of your defense or prosecution, and then the various parties and players kind of working and interacting together. Absolutely critical, I think, to have kind of that unified voice and somebody who's able to work with the sheriff or the district attorney's office, the courts, court administration, probation, pretrial, and all of that. When you have just an ad hoc assigned counsel system, you've got however many lawyers, but there's not any unity. And so with this and the importance of what we're doing, big benefit is the early assignment of counsel. You cannot do early assignment of counsel unless you have like a public defender or private defender. You have to have some type of organized defense. So with that, and I also want to thank like Judge Specia, Judge Kazin, Judge Huff. I'm not sure if Judge Huff's in here. We've got a lot of, there you are, a lot of elected officials, any elected officials from Bexar County that I didn't recognize, and those that are potentially watching, I want to say thanks. Judge Casey, yep. So, incredible group. I've had a chance to work really all across the state, and Lubbock I love Austin, love Houston, but I am so happy now to be in Bexar County, because one of the things that's, I think, unique to Bexar County is the culture and the people. The electeds are willing to check their ego at the door. They're very solution-oriented. It's not that there's not heated and conversations and things like that, but what I see is I see electeds and department heads and others really kind of coming together to try to solve problems. And our county commissioners have invested heavily on community supports for mental health. Haven for Hope is, a recognized model. So this is a great environment to come into, and I came into a jurisdiction where the system wasn't broken. They wanted to go ahead and improve it. So, next slide. Our team, and I'm not going to go into detail, but we've got a relatively small team. When we're totally staffed, we'll have 16 persons. We have 4 divisions. We have a trial division with an immigration Padilla lawyer, law and technology, folks that work supporting on the trial side. The part that's relevant to this is our mental health division, which is under professional development, mental health, and holistic defense. We received a grant after the original grant to set up. Now, we only have a team of 3, but it's a mighty team. It says the mental health resource attorney in process. I'm pleased to report that we do have an incredible lawyer joining us from El Paso who helped set up their mental health defender, Stephanie Canaro. She's going to be joining us. The group is led by Jessica Cantor, who's the director of our professional development, worked with Trala, has done a lot of work in representing the mentally ill, and then 2 incredible other team members, Brittany Phelps and Jose Castellano, mental health case manager. So we only have 3 that are dedicated specifically to mental health. Can we go next slide? What we're going to do is, with the folks that we have, is we're going to leverage others. So we've got 2 specialty courts, one led by Judge Huff, the other by Judge Ron Hell, so on the county criminal courts and then the criminal district courts. So our team will be working with the panel lawyers to help them, those that need help, to identify those persons who are living with mental illness and who could benefit from the services. In addition, since we have 2 persons specifically dedicated, we're, needless to say, not going to be able to handle all of the cases going through Bexar County, but perhaps 50 or 100. We'll have Jose and Brittany will have specific clients that we're working with, not unlike the model that we had in Lubbock, Texas. In Lubbock, we had, I think, 6 mental health case managers. So I do see that number expanding. But for those that we're able to provide services to, data is going to be king, because if we want to expand that, we have to be able to show what type of impact our people are having. And then with our team, they'll, needless to say, be working with the various community supports that are available in Bexar County. And what I'd like to say is, I think one of the most important things that Dr. Keller said in the first presentation yesterday is divert or diversion. So if we're able to keep the person from getting into the system, that's better than even providing early assignment of counsel, because then it's not necessary. And we're going to have a little bit more on that later, but one of the key takeaways for me in his presentation is let's go ahead and divert, and we've got a number of initiatives. So with that, Kathleen?
All right, and I'm going to talk a little bit about TIDC. And so show of hands, who's heard of TIDC before? Yes, all right, we win, Jim. No, the TIDC, the Texas Indigent Defense Commission, of which Jim was the original executive director, we do 3 main things. We oversee indigent defense through fiscal and policy monitoring. We improve indigent defense through training, publications, and most importantly for this presentation, build new systems like managed assigned counsel and public defenders. And then we also do funding. And I hope anybody here who is interested in building a new system, find me before the end of the conference. And also I'll be at a lunch table today as well. We provide funding for new systems like the Bexar County MAC, in addition to a number of other improvements. So what does that look like? Well, just 4 years ago, there were half of the number of managed systems that there are today. So 73 counties today have a managed system of some kind. And I use that term because that's a MACs and public defender offices put together. That is 36 different offices. And just to talk about some of the folks that are here, I know Jay Wooten is here, who's the chief of Galveston. I know Dallas is here. We also saw, Joe Stevens earlier today, who really helped me out with our presentation, so thank you for that. And of course, Elise Ferguson from Collin County, who has one of the original mental health MACs, and I've learned so much from. So it's really neat to see this momentum that is building throughout the state. Jim?
Very good. Next slide. Fair defense. Next slide. Not going to spend much time because we don't have much time on it, but really the impetus of this is the law that passed in 2001. You can see it's embedded in both the federal Constitution and the Sixth Amendment and our Texas Constitution, Article 1, Section 10. So the right to counsel was recognized in Texas in 1876, the importance of it. When Gideon was handed down, which next year will be the 60th anniversary, hard to believe it's 60 years later, but when Gideon was handed down, the Supreme Court said the right to counsel is so important that the states also have to provide it in felony cases. Then they extended it to misdemeanors, and they extended it to the juveniles and Regal. Texas at that time basically told its 254 counties, set up whatever system. So the easiest system to set up is the ad hoc assigned counsel, where you just have a wheel and the judge makes the assignment. So in 2001, I think Texas we had like maybe 7 public defenders. Some weren't even, full, like one of the first public defenders was the juvenile public defender in Travis, established in 1971, but only for the limited purpose of juvenile. In 1999, Texas Appleseed commissioned a study on how well we're providing these services to persons who are too poor to hire counsel. Not surprisingly, we did not get a good grade. If you also remember what happened in 2000, we had Governor Bush was elected to president. So there is a big spotlight on our Texas criminal justice system. And since we do have the death penalty, there is a lot of opportunity for improvement. Ironically, in 1999, there was a fair defense bill that got vetoed by Governor Bush. 2001, Governor Perry signs into law the Fair Defense Act. So that, again, 38 years later, and for the first time, and thank goodness, and there's no way in the world I would have applied for the position if there wasn't funding associated with it. So the first time in the history of Texas did they provide some funding for indigent defense, required some reporting so that we could tell what is going on, and an organization to really help local jurisdictions meet the basic requirements. Now, the one thing my friend Jeff Burkhart, my successor, at the Texas Indigent Defense Commission, great guy, phenomenal what they've done with the team. I'm so proud of the work that they've done. But in March of 2002 is when I was hired as its first director, then task force, and had the opportunity to work with all of your jurisdictions over the course of my tenure there. 10 years later, we did an omnibus bill, taking the task force, which normally has a limited duration, turning it into a commission. It's been chaired by the Honorable Presiding Judge Sharon Keller. The opportunity that I had to work with the people on the commission was really quite remarkable. Next slide. This pertains to access to counsel. In 2002, when we looked at it, we had probably 30, or not when 2002, it's probably about 2004 before we had the data, but we saw that I think it was close to 40 counties in Texas that didn't appoint in misdemeanor cases. That's been required since 1972. Of course, on the felony side, there's not a criminal district court judge who would want somebody kind of going through a felony case pro se. But on the misdemeanor cases, it was like, hey, this is going to cost us money. And and these are kind of some of your smaller jurisdictions. So with that, I know we still have less than a handful of counties that haven't appointed in a misdemeanor case. And I know the state's working with them. But you'll see the average appointment rate in a felony is around 75%, and then 44 or 45% in misdemeanors. I think those tie in pretty close with the national averages. So what does that say? it says really 60% of the persons that are going through our criminal justice system are too poor to hire counsel. And what Joe said early this morning in his presentation is that intersection, when they have that intersection at the 1517 hearing, there is so much that can be done to help that person, and you'll see that there's benefits also to the county by providing that counsel early. Next slide. And again, this kind of ties into it as far as the self-represented. There's not as many pro se. There's practically no pro ses on the felony side, but there were many, many more pro ses on the misdemeanor. Next slide. Next slide. This, and we're not going to get into all the legal semantics, but in 2008, the United States Supreme Court heard on March 17, Section 1983 civil lawsuit that was filed against Gillespie County. Walt Rothgary brought the lawsuit. Andrea Marsh was the representative. She was then the chair or the executive director of the Texas Fair Defense Project. It literally was her first civil lawsuit to file, goes all the way to the U.S. Supreme Court, argued against St. Patrick's Day 2008, decided in June of 2008. And what the Supreme Court said is right to counsel attaches at that 1517 hearing. Did they go as far as and say that you have to assign counsel at that 1517 hearing? No, it could be interpreted that way, but they didn't go that far to say that. But they said it attaches, which was, provided some meaningful clarity. And it came out of Texas. The Supreme Court was 8-1. There was only one dissenting opinion. And as far as the story, I don't think Mr. Rothgary had any mental health issues. I did have the opportunity to go have lunch with him and Andrea Marsh. I went and watched the thing. I did it on my own expense. I didn't have the state reimburse me, but it was absolutely an incredible opportunity to see and just kind of awestruck going in there. But got to have lunch with Walt and Andrea and the rest of the team right after that hearing. And basically, he was requesting counsel from the very beginning. He was charged with a felon in possession of a weapon, so unlawful carrying of a weapon. Well, problem was it was predicated on something that purportedly happened in California, but it didn't happen, so he was not a felon, so he was actually not guilty. Case wound up getting dismissed. However, since he wasn't provided counsel, he was able to post bail the first time. No counsel, and if he had gotten counsel assigned at the beginning, that could have been rectified and maybe resolved in maybe 30 days or 45 days instead of 10 months later. Well, what happens, he wasn't indicted at that point, was able to post bail, still requesting right to counsel. 5-6 months later, gets indicted, bond revoked, the new bond, he's not able to post. So he loses his job, winds up having to move from where he's at. I don't remember what happened with the marriage, but it turned his life upside down. And for something he didn't do. So that counsel on the early side, whether it's mental health or regular, it really does matter on it. Next. So magistration, you heard about both Aaron and Joe. This is the initiation of it, that 1517 hearing, and it's Article 1517 of the Code of Criminal Procedure. It's when the right to counsel attaches. Next slide. Did you want to?
Yeah, I can take these. So, and that's a great point, Jim. Joe really set us up nicely on this, why early representation is so important. The number one thing, when you have a client who's in jail, the number one thing they want to do is get out. And that is almost such an overriding emotion and thought that when you meet with a client, there is nothing else that they can hear. And that is a main reason why having someone by your side when you're facing the power of the court and you're making decisions that can ruin your life, I heard someone talk about how hard it is to get housing when you have convictions, right? When you have someone there to answer questions, when you have someone there to explain, especially when you're dealing with folks who have mental illness or IDD, who don't even know who the people are in the courtroom, who's that person up there? You know what I mean? When I had clients, I would have to explain who the other people were in the courtroom, who I was, who that person was at the other table, right? And you do a lot to help that person, that human being in front of you, settle and just have a moment. And then for our judicial folks in the room, also, frankly, keep them from saying something that they shouldn't be saying in the early hearings, right? Has anybody seen that where there's that natural impulse to explain why I shouldn't be here or why you need to let me out because I didn't do it, right? I mean, has anybody seen that at a hearing? Right. And, you know, we have amazing people, amazing judges, amazing DAs who know what to do in those instances, right? But when you have the defense counsel there, like when you have Jay's office there to help explain and start the process of, especially if you're mental health or IDD, like, okay, I want to get you out on this mental health bond, but we got to start talking about where are you going to live, who you going to talk to, where are your family members, and so on and so forth. So it's getting folks out of jail, and then also, as Jim mentioned, there are people that are arrested who are innocent, looking for clients, witness interviews. Those things disappear, truly like vapor into the, like fog, into the wind, minutes, hours, days after someone is arrested, right? So those kinds of things from a practical perspective apply to everyone. And that's why I'm so proud to work at TIDC and see those numbers go up, up, up. But then also when we're talking about mental health and IDD, access to treatment, services, having better case outcomes. Meadows Mental Health is doing an evaluation of the Galveston Mental Health PDO. And I already know it's going to be great, but it's going to be really neat to have evidence that shows what these early interventions from the public defenders and the appointed counsel are able to do. And I guess I'll do this one too if you want to.
Yeah, that'd be great.
So county officials, why should you also like early representation? Reduce jail costs. We have a really cool publication on mental health defenders that is full of stats. But what we see overall is that this reduces jail costs. When you get people out of jail with a release plan, with public safety in mind, not just good luck, but here's where you're going, here's the treatment we're going to connect you to, and so on and so forth. We see reduced jail costs, reduced failures to appear, and then we stop that cycle. And that's what's really important about having that person by your side.
Let's
Yeah,
kind of
I'll
skip
take
towards
these.
the end because I think we're getting close on time.
So,
What I'd like to kind of say, and do we have till 11 or 11:50? 11, okay. What I want to do kind of in closing is basically say if you don't have an organized defender, whether public defender, managed assign, or some other type of offshoot, I'm not sure exactly what that would be, is you're not going to be able to, in a cost-effective or meaningful way, provide counsel at that 1517 hearing. We have only 6 or 7 jurisdictions across the state that provide early assignment of counsel. Bear, Harris, one of the first, I even think like down in Cameron County they do. Hayes, and I think Galveston, are you all doing, yeah, you're definitely doing early assignment of counsel. That positive impact that you can have. So there's like huge opportunity there if you don't have one. You've got TIDC, you can call me, I'm sure you can call Joe, you can call, we can work you through that. The state has money. I'm not saying you're going to get, but this is the type of things that they want to invest in because it improves the overall system. The formula grants, you know, kind of keep the wheels greased and the commissioners happy, but the discretionary funds that they have is where you're really seeing the game changers out there, where you're really changing the system, and regardless of how good the system is, it can always be made better. So take advantage of those state monies. The last slide is kind of talking about what's next. The TIDC has had to submit its LAR, legislative appropriation request. I know Judge McClure's familiar with that. Anybody state, summer, you're getting all that prepared. They're asking for an additional $50 million to really kind of expand these services in rural jurisdictions. The big urbans, Bear, us, Dallas, Harris, Travis, Tarrant, et cetera, we're going to benefit from that as well because the urbans get the biggest percentage of the formula. My only criticism of that is I really think the state should be fully funding indigent defense. This is something that they've passed down to the counties. I'll be working with our legislative liaison to get the state to step up on this. And as we know, on mental health, on the beds where they approved last session, 25, and what's the need. So the state really does, on some of these things that are global, needs to step up and provide relief to our local jurisdictions on that. So with that, I'll turn it over to Kathleen for final remarks.
Sure. I think this is a great place to end. We didn't get through all of our slides, but that's okay. When it comes to being a defense attorney, when I graduated 12 years ago, there was still a lot of how can you defend people who do terrible things? And I'm like, well, it's a lot more complicated than that. And thankfully, I don't hear that today. I actually go to law schools and I hear young people say, I want to be a public defender. I want to do this work because I want to make my community better. And I love hearing that because when I started 12 years ago now, it is different representing folks with mental illness and IDD. You have to hold that space and that lack of judgment that Dr. Lepore talked about. You have to be that connector. This doesn't replace the social worker. This doesn't replace the treatment providers, but you're the connector. You're the person that can talk to the judge, talk to the treatment people, talk to the DA, talk to the family, and make sure that everybody is on the same page with getting this person out of the system. And that's why I'm so passionate about building mental health managed systems, whether it's a public defender or a MAC. So if you would like this in your community, and it doesn't matter who you are, the Texas Indigent Defense Commission will write a planning study for your county. Shout out to Judge Mollier. We worked together on Galveston. And so if this is something you're interested in, I encourage you to learn more because times have changed and this movement that is happening is a really powerful and beautiful thing. So thank you for letting me be here today and for hearing us out.
Okay, well, that was wonderful. We actually have a bit of time left for some pointed questions for our two panelists. And point of privilege, I'm going to ask the first one. The first one is, what do you think the role of early assignment of counsel is in pretrial diversion?
Question, really, what's the role of early assignment of counsel in pretrial diversion? Absolutely critical. If you have your lawyers that are trained on what supports are out there. One of the things we're going to be doing, Beth, in Bexar County is emulate what Lubbock's doing in a number of jurisdictions, have a wheel of lawyers that want to practice mental health, who receive extra training. We're going to start with 15, 20, 25 and expand that. So with that lawyer identifying it, that they have the mental health, then getting a lawyer that's trained in it, because those of you that are representing know that these are challenging types of cases. And so it can have a really exceedingly meaningful impact by providing the lawyer, but the lawyer does have to be knowledgeable on what placements are available to in your local jurisdiction. Kathleen?
Absolutely. And from a practitioner's perspective, one of the things that that I hear about from judges and prosecutors is kind of being frustrated with who gets referred to these types of programs. And so what's great about specialized defenders that have specialized training is you have that space with your client. That's protected. It's attorney-client privilege, and that's a powerful thing, right? Like, you can say whatever you need to say to me, but for certain exceptions, I'm not telling anybody, right? And so that allows you to create this relationship with a client, and then you are knowledgeable, like Jim said, also just even knowing what's available in the county. Because if you have a decentralized system and you set up all these great programs and then nobody gets referred to them because none of the defense attorneys are working on it or they don't even have counsel, then you're really missing this opportunity to bring people along and then also find the people that will be successful. Because that is the other really important thing, is knowing who's going to do well and who do we need to find other solutions for.
Well, I appreciate that. That's a really thoughtful answer. Who else might have some questions for our panelists this morning? We do have the mics here on either side, and I would ask you to come up to the front to ask the question. Sometimes I forget to repeat the question, so I want everybody to be able to hear right off the bat. Oh, good. Joe.
Revenge.
Question, absolutely. I'm curious how y'all address the question that I get very often when I talk about public defender offices in rural communities. Sometimes the communities have an active defense counsel population who actually makes a huge living taking court-appointed cases. Obviously, there's different incentives on their end to close cases, and some do a great job and some are a little less active. How do you answer that question? What is the impact of the public defender office going to be on the local defense bar?
Joe, great. I'll go first. There's 3 pillars of, I think, an effective indigent defense system. One is access to counsel. The other is pertaining to the quality, and the other is kind of public trust and confidence. So what do you say to the defense bar on this? It's a support. Whether it's public defender, if it's private defender, we're actually utilizing the local attorneys to do that, and we're able to manage it. So end of the day, it's a support. And then Aaron talked about use of data. So then what you need to do is say, okay, in these types of cases, kind of taking a look at outcomes. And again, the private bar does a good job, but when the private bar is getting paid, say $190 on a misdemeanor case, and that's in 99% of the cases, how much effort is going to be put into that? So you either have to, compromise your rules of professional responsibility, or you have to basically supplement what should be the government paying you for that. The challenge I had, and I know TIDC had, is whenever you set up a MAC or you set up a public defender, it's not going to save, you're not going to be able to show savings to counties. There's a lot of cost avoidance dealing with the quality of the representation and things of that nature. But at the end of the day, one of the reasons, not one of the reasons, but we're 48th nationally in per capita kind of spending. I figured if I come in and screw it up, we maybe fall 1 or 2 slots. So we still nationally are well below what's being provided. And in order to have good, strong programs, whatever it is, whether it's Defender or whatever, there has to be adequate funding. You're not going to be able to make what you're making private practice. So I kind of go through that. Judge Kazin?
We came up old school criminal defense, and that's no, we're going to get them out. Absolutely not. But there's been this explosion of specialty courts, drug courts initially, mental health courts and the like. Can you speak to what we can do to help defense attorneys bridge that gap from being the no, my client's out, it's freedom or nothing else, to maybe this is not such a bad thing for you?
Yeah, and what we'll be doing, and I'll be super short so you can actually have an opportunity to say something too. That's the problem. You got to just interrupt if I go on too long. But really, it's going to be through training. I've got out of those 275, there's probably 25 or 30% that think this is not going to work. I've got probably about 50% that are kind of in the middle thinking, okay, are they going to be able to deliver on what they've said? And then we've got probably a good 20, 25%. So I really think it's going to be through training. And then both the quantitative and qualitative, you got to have the data, but you also have to have the stories and show the impact that you've had on that. So I think they have to look at us, whether it's MAC or public defender, is an ally and as a partner. And the only way that's going to happen is through, good communication with it and really explaining, here's what the specialty courts do. These are the positive impacts. But you're right. Defense lawyers it's no, and it's kind of to deconstruct, not to build a system. So my toughest audience always was, whatever jurisdiction I went into, was a criminal defense bar. And it's an important player, and they have valid concerns. Kathleen?
Yes, no is my favorite word, Jim, so, but to answer both these questions kind of together, in a lot of rural communities, there are no lawyers, or they're leaving, or they don't take these types of cases for the financial incentives that Jim mentioned. So that's why TIDC has a program where we fund 2/3 of rural regional offices. And we have $2 million a year set aside for mental health specifically. So we have these different incentives, but I think what it comes down to is building these systems in these rural communities because there's nothing there. Where there is a strong private bar, we can work with the private bar. Managed assigned counsel systems are, a way to be a force multiplier to the private bar, right? Now you don't have to worry about where to get a social worker, where to get an investigator, right? A place to take, just to workshop ideas as a private practitioner can be difficult if you're not in a firm. And then to talk about your question, Judge, that's something I personally have struggled with, And I think when it comes to the ethical responsibilities of the defender, it's always going to lean more towards protecting the interests of the client or what the expressed interests of the client are. But when you establish that relationship with your client and you make that connection, that's where you have the breakthrough. And I think the problem with our legal education today is we're not teaching the empathy and the patience you need to have that space, right? And so I think there's a combination of building new systems. I don't know why, Joe, you're now you're the person for that. But building new systems and training up and finding those kind of people who want to be that different type of lawyer, I think those two things together are how we're going to close this gap and get this need. But that's a really great point.
Well, help me thank our